So I'm going to try to unpack this concept of trademarks and what in-house counsel should do with respect to trademarks by just presenting a number of really what are unremarkable cases, but what I've been involved in and am involved in all the time. So please, this is your presentation, not mine. God bless the broken road. Who knows where we're going to go from here? But please ask questions, and we'll see where we end up. First case, Landis Communications, my client, marketing firm in San Francisco, California. And then the other side of the coin, and by the way, all these cases talk to the clients. They said, absolutely, you can present the information on them. The other side, Landis Communication in St. Pete Beach, Florida. Can anybody spot the issue here? My client, been around for about 25 years, 40 or so employees, tens of millions in revenue. They have accounts all over the place. Their employees get on planes all the time. And by the nature of marketing work, their work product gets all over the country and actually internationally. Won all these awards all over the country and internationally. Great people. Never thought to file a trademark. The other side, Landis Communication, do the exact same stuff, PR and marketing firm. Been around when I got involved, about 2 years. 2 or so employees. Maybe they had some revenue, who knows. Mostly located in Florida. I think they were good folks, but just kind of questionable judgment. And they too had never filed a trademark. Type in Landis Communication or Landis Communications. This is what you end up with. And I was, one of their clients or one of their attorneys, and I myself couldn't even really look at this and which one am I supposed to contact? So obviously, emails, phone calls were going to the wrong parties, and it was getting worse. This is my client, their website, top corner, says Landis Communication, public relations marketing firm. This is their website, Landis Communication. What I love about it is, I don't know if you can read on your slides, but the first line on their website is crisp, clear, purposeful communications, and they went out there to, we'll help you, define your company and your products and all that, and I couldn't even tell. So, is there an issue here? Absolutely. The standard for trademark infringement is whether there is a likelihood of consumer confusion, and that's based on the similarity of the goods and the similarity of the services. So, obviously, I should also mention, we were using landiscommunications.com with an S, and they were using landiscommunication.com without an S. So that was another issue. So when I got involved, I looked at this, and I said, well, we have an issue, and it's only going to get worse, not better, over time. So anybody have a guess what we did, first thing we did? Yeah, so I heard both of the, absolutely, filed a trademark and sent a cease and desist letter. So the big issue here is neither party had a federal trademark application. When you file a federal trademark application and you get it granted, you have the presumptive right to be the only one to use that mark across the entire country. Unfortunately, when you don't have a federal trademark application or registration, you are relying upon what are called common law rights. And what that means is you are only developing trademark rights in the geographic area in which you're using your mark. Well, I submit to you, in the world where everybody has the internet in their pocket, what does that mean? And as surprising as it is, the trademark bar really doesn't know. So that's a big issue. First thing I did when I got involved is I told the client, well, we need to protect your marks, and I think we filed 5 or 6 trademark applications. So we protected Landis, Landis Communications, Landis PR, maybe a couple other ones. But the problem there is that those, even if we get those rights granted, this other party has started in Florida, and our federal trademark rights would not kick in until after their date of first use. So, as unfortunate as this situation is, I had to counsel the client that there's a very real possibility here that despite the fact that you have had all the success, despite the fact that you're incredibly well known, despite the fact that you have clients all over, we may not be able to get this other party to start or to stop, which is really kind of a shock to my client and clients that get involved in these situations. So we were successful. And how I approach these topics is, you know, so much of law work and is adversarial in nature. But trademark issues, I really don't think that they're adversarial. At least I don't approach them that way at first. I approach them that this isn't me versus you. This is you and me versus the problem. You know, consumer confusion is not good for either of these parties. So how can we work this out? Is really where I start. But the scary thing is, what if the other side wasn't willing to stop? And another topic too is the gentleman that started Landis Communications. His name is David Landis, and the gentleman that started Landis Communication, his name is Jesse Landis. And there's some also, you know, about the trademark laws don't want to prevent somebody from using their name, so that was another wrinkle in there. But so that was that case. Any questions on that before I launch into? Yeah, please.
So I don't know how long you were representing Landis, but do you ever advise your clients to buy multiple domain names? Because I know a lot of times if you were to type in landiscommunication.com, it would just redirect to the landiscommunication.com. They bought up all those domains. I don't know, you know, like checklists you go through the clients on that, or
sure. I do help clients with that, and it is absolutely a very wise idea to buy up whatever domain names that you think would be helpful to your company. You know, by the nature of what I do for a living, like, yes, anything that's prophylactic in nature, I always see the benefits of it. I don't see the cost. You know, because domains, there's a certain cost. It's minimal, but for each of them, if you buy up 100 of them, you know, that's actually a measurable cost. So the interesting thing about domain names versus trademarks, you can register as many domain names as you want and you never have to use them. Trademarks, on the other hand, you actually have to use them. But the other topic that we did talk about is, so there is this statute called the cyber squatting statute, or I forgot the actual name of it, but it establishes cyber squatting. So cyber squatting, if somebody registers and uses a domain name in essentially a nefarious way, intentionally trying to infringe or take you know, website traffic from you, we can file this domain name dispute resolution policy, and I've been involved in that a number of times, and I've never lost, not because it's just because you don't file them unless you really have, you know, straightforward rights and you really think you're going to win. If I remember correctly, I'm not going to articulate it perfectly, but there has to be a certain intent to infringe or take rights away from you, so you could file that. I don't know if that would apply in this case. We did discuss it, but you know, was Jesse Landis really trying to infringe upon David Landis's website by registering landiscommunication.com? No. The trademark cease and desist was probably a better route for them. But that's a really long way of answering your question. Yes, register whatever domain names you think. You will never be able to register all of them. I mean, there's .com, .net, .org, .xxx, all this other stuff. You will spend, no matter how big your company is, you will spend all of your money registering domain names. So just know on the back end, if somebody is intentionally infringing upon you, we can take that domain name away from them through a Domain Name Dispute Resolution Policy Act. Does that work? I think it was 2000. It's been around for a while, and it's really, I mean, there's bullet points laid out. You submit it. It's essentially, you know, everybody that registered a domain name, you agree to these rules, and I think it's, you know, it goes to a panel of three ex-judges, and they make the ruling, and it really works quite slick. So, thanks for the question. Any other questions on this case? All right. So, again, two parties, no trademark registrations across the country, and we were lucky enough to win that one. Another case, very different but similar. My client, White Willow Events, a wedding planning shop here in Iowa, and the other party, White Willow Events in Lafayette, Indiana, also a wedding planning company. So one of the interesting facts here is like when I mentioned that common law trademark rights start, are established by use. So the data first use is an incredibly important thing, and it was unclear in this particular case who had used the mark first. But again, my client here in Des Moines, they filed their business in February. This is known facts, February 26, 2013. Somewhere either before that, we don't quite know when they started using their mark. And really what counts as data first use, was having a post on Facebook, was, doing your first wedding, I don't know. So there were some questions there. Their domain was whitewilloweventsia.com. The other side, Lafayette, Indiana, same exact name, used whitewillowevents.com and .net. And the big issue here, I believe it was that on a wedding day, maybe flowers went to the wrong wedding or linens or something like that. And having been through a wedding, I know how terrible that would be. So unhappy litigation ensued between the parties. Another fact is, so despite the fact that we started using our domain or our name in 2013, they filed a trademark application in June 10, 2015, which was registered in 2016, and then shortly thereafter they filed a cease and desist against us after the flowers went to the wrong place. Go to the internet, very similar situation, White Willow Events, like who are we getting? Very hard to determine. You go to the websites, this was my client, you go to it, White Willow Events, go to them, White Willow Events, no indication whatsoever as to where they are. Another interesting wrinkle is there was also a third party, White Willow Events in Canada. And that is actually what I really think ticked off the other side more than anything is this, whoever owns this entity, they posted some pictures and somebody commented to the other side, and then they came after us, and it's really interesting because there's a bunch of pictures of mountains and an ocean in the background, and we're like, he's like, that's not Iowa, that can't possibly be it. And so we literally got engaged because of a third party. And then there's just another interesting fact, White Willow Bridal literally positioned halfway between my side and the other side. So let's unpack this a little bit, going back to federal trademarks and common law rights and all that. We got engaged by the other side. They wanted us to stop using our name. And they said, well, we have a federal trademark registration. Okay, but you got that 3 years after we started using our name. And we understand that, you have the exact same name as us and it's registered and all that, but based upon common law rights, our position was you can't make us stop. Was I right or was I wrong? I think I was right, and we got them to stop coming after us, so I guess I was right. But the interesting thing about this situation is, it's the story of the dog chasing the car. What would it do with it if it caught it? I had to sit down with this client and say, look, even if we are as successful as we hope to be, there will always be, what's going to happen is they're going to stop coming after us. And I was hopeful that they would do that sooner rather than later, which didn't necessarily happen. But client, you have to understand there will always be two White Willow events, and unfortunately both located in I states, Indiana and Iowa. And what I tried to do, again, in the spirit of this isn't me versus you, this is me and you versus the problem, tried to go back to them, the other side, and say, my first thing that I really wanted is I wanted my client, if the other side goes out of business, I want to own this trademark registration so that we get the entire, the presumptive rights across the entire country. So I wanted to put an agreement in place. And then I also wanted to work with the other side that, we said very reasonable things, or what I thought were reasonable things, like what's the distinction between the two parties? We're in Iowa, they're in Indiana. Let's both adopt whatever you say to me to help resolve this problem. I want you to do the same. I thought that was reasonable. We'll put Iowa, White Willow Events, Iowa in bold letters or something like that. If you put, White Willow Events, Indiana or something like that. And of course they were unwilling to really do anything. They just wanted us to change, and I didn't think that would solve anything. So I guess the summary of this case is that even if you have a federal trademark registration, your federal trademark registration only gives you rights. You know, it gives you the presumptive right across the entire country, but you can't stop others from using a mark that they were already using in the geographic area in which they were using the mark, and, you know, although this is squishy, a reasonable area of expansion. So again, back to what the client can and can't do. My client can continue to use their mark in Iowa and somewhere around there, but we certainly couldn't open you know, another facility in Chicago or Indiana, and it's certainly questionable if we offered, you know, wedding planning services, let's say, in a different geographic area. You know, she said, can I do a wedding in California or Florida? Absolutely, I think the answer is yes. What are they going to do? Engage us? But it brings to light a number of, you know, gray area and issues that all could have been solved if you would have filed your trademark early. So, any questions on this or wrinkles that you'd like to explore or take apart? Please.
Once they filed that trademark, didn't they have an obligation to protect their trademark to go after your client, or the trademark is less valuable? When does that start to occur? When, you know, you got your trademark and
Oh, sure.
you need to send nasty letters to other people to protect you?
Sure. So the question was, once they had their federal trademark registration, did they have an obligation to enforce it or police it? The answer is yes. When you own a federal trademark registration, you have the obligation to police your mark. If you do not police your mark, then you're essentially giving somebody a license to use it elsewhere. Now, that gets complicated in maybe some of the slides later, but the key that I suggest for everybody that's in-house counsel here and protecting the interests of companies is, yes, police your mark. The vigilance favors, I'm sorry, what is it? The earlier you pursue against somebody else, the better. The problem in this case is that neither party was really aware of the other until later, after they, you know, years later after they had these issues and, you know, had established their common law rights. But in the perfect world, if you have a trademark registration, enforce it. That makes sense? Did I fully answer your question?
Just kind of on the same topic, initially you said you have an obligation to police your trademark, make sure someone else isn't using it. You said that you have an obligation to police your trademark to make sure that someone else isn't using it, but in that case, there wasn't an issue until they found out about each other. So I guess, what is that timeline of policing your trademark look like? I mean, once a year, do I need to set a reminder and Google all my trademarks to make sure someone else isn't popping up, or am I on constructive notice?
So, all right. So the kind of all-encompassing answer here is be aware of your trademark rights. Be purposeful when you're selecting a trademark. In that particular case, you know, you can see that she kind of knew there was an issue before she even started using her mark, because she could not register whitewillowevents.com. She registered whitewilloweventsia.com. So maybe that's a first and early indication that, okay, there's somebody else out there that is desirous of having a similar name. And I think they registered that domain just a little bit before we started using our domain. So be aware of that, hey, here's a red flag, there might be an issue. And then, you know, in the perfect world, you file a federal trademark registration even before you start using the mark, so that you establish rights across the entire country. And then that gives you the right to prevent others from using the mark later. In this case, essentially both parties started using about the same time, so one couldn't prevent the other. Did I answer your question? And we can talk more about policing your marks down the road here. Let's shift gears to another somewhat similar and similarly unremarkable case. These are just very simple cases that, you know, I deal with all day, every day. But my client, Mississippi River Distilling Company, they're a distillery in LeClaire, Iowa. They have the trademark lowish for distilled spirits, or actually whiskey. And then lo and behold, the Great River Brewing Company in Davenport, Iowa, only 14 or so miles away, started using lowish for beer. So we have a pretty substantial issue here. We've been around for about 8 years. We distribute our alcoholic spirits all over the country. This client, they promptly file their trademarks, sometimes before they even use them. The mark was filed in 2013 and registered in 2014. The other side, a craft brewery about 14 miles away, had been around for 10 years. They had just started using this name, and we were aware of it. I don't quite know how we were aware of it, but they started using it just in the tap room, and the issue was that we were concerned that they were going to start canning the beer. Again, we registered the trademark well before the other side ever started using it. One little wrinkle here was we had registered it for whiskey, not alcoholic spirits. So the question there in the alcohol space, which is very interesting, the alcohol space, there's 3 areas that I've been really involved in where trademarks are just so incredibly important, and that's pharmaceuticals, agricultural chemicals, and then alcohol. For whatever reason, those are all trademark issues are rampant, and it's very hard to get trademarks in that area, and if you do get a good trademark, it's an incredibly valuable property. But this was our product at the time, lowish, and then this was, what was on their website about the beer that they were starting to sell, lowish. And there's always, with these cases, there's always something that just absolutely infuriates the other side. And they're like, this is, it just makes it so personal. And, like in the White Willow events case, it's like flowers went to the wrong place. She knew what she was doing. I don't know. Interesting. This one, they even stole our font. And it's just it's just vitriol. And yeah, I like to think that it was a coincidence, but it is without question. There's always this one little fact that my client or the other side just can't get over, and this was the one in this case. So, is there a likelihood of consumer confusion? Absolutely. What did I do in this case? This is a perfect case for me. We filed our federal trademark registration well before they ever used it, and the marks are identical, the goods are very, very close, so this was a very easily resolved situation. And this is kind of, I guess, a model for, my clients or for you is hopefully you put yourself in this position. Look before you leap, establish your rights, and everything will flow downhill from there. With that said, what are you doing, other side? Look before you leap, too. You're 14 miles away. You're selling a very similar product, and you're using, maybe you did it intentionally, maybe not, but this doesn't look good when you go to a jury or a judge that the marks look identical. So, yeah, that's where we are with that. Any issues or questions on this case? And then I can just read slides thereafter.
This is a question kind of applies to how often you should apply for the trademark. So with that distillery, your client in that case, did they file trademarks for every name for every product that they make, or do they have the trademark or the mark for their company? I just imagine that being an issue if you're a brewery or you're a distillery and you have seasonal beers, you have seasonal beverages, or you have your stalwarts, the ones that you have all the time that are on tap or are available. It just seems like an expensive proposition to try and trademark all of those. I'm just curious what your recommendation is. I see that applying to a lot of companies for a lot of smaller products or something that they're trying to roll out regularly.
You nailed it. That's absolutely correct. And that's what I discuss all day, every day. Now, I'm biased. I'm blessed to have had a lot of education, and in so many of the classes, let's say my MBA, the first day the professor draws a circle in the center with spokes and circles and all that, and whatever the class was, it was a marketing class. Marketing went in the middle. Finance and management and all that. Those are less important than marketing. for me, what's in the middle of the wheel is intellectual property rights. I see the benefits all day, every day of protecting your names and doing what this client did, did right. So I think it's very important. With that said, you guys being on the other side of the table, you have to pay attention to costs and so where do you draw the line? This particular client, they did protect their business name, which is absolutely critical. They did protect the products that they thought they were going to sell continuously, and they do protect the marks that they think they're really onto something or something that they're going to invest heavily in. But the seasonals, the one-offs, all that, they don't protect. And you are absolutely correct. With the breweries, that is an issue. I mean, it seems that like a third to a half of the breweries have a trademark issue because they are offering tons of different products. There's one in the paper recently here where somebody will open a brewery under the brewery name or under somebody else's beer name. So it is an issue. The other thing to think about too, so as general counsel, how distinctive is my name? Like Red IPA. That's more descriptive than it is anything. That can't really be protected. But if it's something like Iowish means nothing, and no one's ever sold an alcoholic beverage under the name Iowish. So that was clearly something that we could own. So to get the answer, I mean, it's a great balancing act. I often tell my clients that my job's easier than yours. You have to make the decisions. I just present the options. And in this particular case, it worked out for him. But it seems like, and again, maybe I am biased, the center of the wheel. But if you are in that conversation and you don't protect the mark, it always seems like that's where the issue arises. So, kind of unfortunate. Any other questions about any of the cases that I presented, or I could go on and on and on, but I just presented 3 here. And I guess we'll kind of launch into sort of the boring overview of what trademarks are. So, just kind of trying to package everything. What is a trademark? A trademark is an indication of source. When you look at what's at the bottom here, it could be just 2 letters or numbers, a symbol, a logo, a pattern. For the women in the audience, maybe what comes in that box, so it can be a color. Could be the shape of a product, or some people might know who made that shoe based solely on the color of the sole. So names, symbols, colors, even sounds and smells can serve as a trademark. As I mentioned in these cases, there's 2 types of trademarks. There's common law trademarks, which are acquired simply by use, and then registered trademarks. There are 2 types of registered trademarks: federally registered trademarks and state registered trademarks. I can't tell you how many federally registered trademarks I've registered. It's in the very many category. But when it comes to state registered trademarks, again, in the world of the internet, state trademark, I've only filed 1 or 2 of these. The rights only extend within the borders of the state, and that's pretty much valueless today with the internet as it is. So we kind of talked about some of the benefits of federal trademark registrations, but I'll touch on them again. Presumptive right to use the mark throughout the country. You get to use the R symbol, which really doesn't mean anything except for it indicates that you've registered the marks. And you can sue in federal court. But really most important of anything, I think, is if you're going to use a mark, where are you going to go to determine whether you're infringing somebody else's mark? You're going to go to the uspto.gov website and you're going to type it in. That's the best thing, that's the best part about having a federally registered trademark, is it puts your mark in the place where people are going to look to see if you have a mark. So let's get into the weeds. As general counsel, what do you need to know about if you're going to register a mark? So there's 2 types of trademarks. There's standard character marks and design marks. So when you're filing a trademark, you have a box you have to check, one or the other. There's only 2 types. A standard character mark protects your mark regardless of, if it has characters, so that's letters, numbers, punctuation, spacing. It protects your mark regardless of any design elements. So that's Nike, Apple, Chevy, Shell. if your mark includes characters, this is the strongest type of mark you can get. Because again, it protects it regardless of any color, font, design, logo, whatever. But we have a whole other category of marks, like the Nike swoosh or the Apple that have no characters. So there's no way you can protect that with a standard character mark. The only way to protect these marks is with a design mark. However, we have this entire huge category of, what I like to call logo marks, or, they're also known as composite marks. So they're letters as well as, some artistic or design elements. When you have a mark like this, they absolutely serve as valuable trademarks, and we want to prevent others from using them. But the only way to protect them is, we have to check a box: standard character mark or design mark. When faced with this, you got really three choices: standard character mark, design mark, or both. Again, prophylactic me. The best thing to do is file a trademark for both. But if you can only afford one, I certainly would, in most cases, lean towards the standard character mark, because again, that protects your mark regardless of any design elements. Colors also serve as a trademark, as we mentioned. So, interesting thing about colors as a trademark, they have to tie into, it means nothing in association with the good you're selling. So that insulation does not need to be pink to work. That pill does not need to be purple to work. And if you elect that, then you have a very valuable and protectable right. Sounds can serve as a mark. I used to have those tied in here, but and then I also think this is interesting. Scent marks. So bubblegum flowered sandals, or apparently Verizon stores have a flowery scent, so you could prevent your competitors from offering that same experience. So that's really registering the trademarks as we know it. But a very important area of trademark law that I get involved in is what's called trade dress. So trade dress protects, a distinctive appearance of something, the look and feel. So, what number of products down here, that cracker doesn't need to be in that shape and does not need to have that look and feel. You can compete against and you know exactly who made that. You can compete directly against Pepperidge Farm by selling crackers in any other shape, right? You're selling crackers. But I submit to you, if you started selling a cracker, anything shaped like that, you're going to get a serious cease and desist letter. So, as general counsel, when it comes to these colors, try to, if you want to develop trademark rights, select something that's very unique and not related to the function of the product. And same thing here. A bottle can be any shape and serve its purpose, but you can develop valuable trademark rights by selecting a shape that is unique to you, and you become known as the indication, or I'm sorry, the source of those products. Does that make sense? I'm fascinated by trade dress law, and it's a growing area of law, and something that really raises a lot of interesting questions. Happy to talk about it further, but I've said this a couple times now. There's two types of trademarks. So we have trademarks, which really are for goods, and service marks. I don't know if any of you have seen SM and wondered what it is. So for you as general counsel, at any time, whenever you're using a mark that you think is a trademark, whether you've registered it or not, whether you've started the application process or not, you can always use the TM symbol or the SM symbol. And what that does is that simply serves as an indication to your competitors and your consumers that, look, we think this is more than just a mark or just a word. This is a mark. It doesn't mean anything with respect to registration, but you're welcome to do that, and it just says, to others, don't use this or recognize this as a trademark. The only thing that you can't do is use the R circle when you haven't registered the mark. So don't do that. That's a no-no. And even when you do have a mark registered, oh yeah, question in the back. Okay. It is not registered until it is exactly registered. So you have to go through the whole registration process, which generally takes about a year, and it has to get published for at least 30 days so the entire society can comment and object to it if at all, if they want to. So there's no way to speed up that process to some degree. But Amazon will not let you sell your products whatsoever because you haven't registered your mark. Interesting. I don't know that I've heard that before. I know there's a way you can register your marks with them, but I'd be happy to talk to you more offline about that. Absolutely. So when you're registering a mark, we have to identify, so again, identify the goods and services that we're using. Make no mistake, the Patent and Trademark Office is a business like any other business, and they want your fees. So what they've done is they've created this scheme of, well, I call it a scheme, that's kind of negative, but all these international classes. We have to identify how you're going to use your mark, what goods and services are you going to use, and for each class that you're using your mark in, we have to pay a government filing fee of $275. So, you know, if you're using your mark with, let's say, apparel and then alcoholic beverages, those are two different categories, so we're going to have to pay two different fees. But hopefully, you know, I can articulate a description of goods and services that, you know, falls into only one category to minimize your costs. But the other side of the coin, though, is the more classes that you identify, essentially the broader your rights are. And also know that you can file a mark before you use it. So you can, there's a basis called intent to use. So if you want to, and I do this all the time, actually probably most of my marks are this way, again, the first one to file a trademark registration gets it. If two parties, you know, file over the same mark, it's the first one that filed it, gets it. So you want to get to the Patent and Trademark Office as soon as possible. Identifying intent to use, or an intent to use mark allows you to do that. The drawback is later down the road, again, I mentioned that you can register as many domains as you want, but you can only register trademarks that you're actually using. So later down the road, you have to prove to the Patent and Trademark Office that you're actually using the exact mark with the identified goods and services before they'll grant your registration. So just want to talk about, we have, when you're going through the trademark selection process as a general counsel, I want you to understand that not all marks are created equal. We have this sliding scale of trademark strength that starts from the arbitrary and fanciful, which are your strongest marks, then your suggestive and descriptive marks are weaker, and then you cannot register generic marks. Examples of fanciful marks are marks that mean absolutely nothing with respect to the goods and services that you're selling. So that's eBay, Twitter, Pepsi, Google. Those mean not, you know, Pepsi means nothing with respect to soda, or Google means nothing with respect to you know, internet search and whatever, all the other things that they do. And those words were created simply to describe, you know, that product or service. Your arbitrary marks are marks that existed, but they similarly mean nothing with respect to, you know, the goods or services that they're used with. So that's Apple for computers. It means nothing. Your suggestive and descriptive marks, those are marks that, you know, suggestive, they suggest something. Red Lobster for restaurant, or Land Rover, I guess that suggests, you know, a car that drives over the road, or land. And then descriptive marks, those are very weak. You know, I can't think of a weaker mark than California Pizza Kitchen. I mean, if that was my client, came to me and said, I want to, you know, open a pizza kitchen in California and call it California Pizza Kitchen, I'd shake them, saying, my gosh, your marks are so weak, it's so descriptive, and actually we may not even be able to get to register that. But if you do your job as a company over time, and that you can develop very strong rights in that mark by consistently using your mark. Now, touching on like Apple, while we could register and use Apple for computers, if you tried to register Apple for apples, that would be simply just generic, and you can never do that. Why is that? Again, when you own a trademark, you get to prevent anybody else from using that mark in association with those goods and services. If we allowed you to register Apple for apples, you could essentially prevent society from describing their apples as apples. Not possible. So just know this, you know, there's a sliding scale of trademark strength, and to the question that was earlier, like about you know, policing your mark, what you can do is you can essentially make your mark stronger by strongly policing it. You know, if you own the mark California Pizza Kitchen, you go against every other company that uses California Pizza Kitchen or something similar, your mark gets stronger and you become more well known in that mark. All right, so as we go through the trademark process, so mention that. The standard for getting a trademark is, you know, whether there's a likelihood of consumer confusion. That's the same standard for if you're infringing somebody's trademark. And essentially the two biggest factors are the similarity of the marks and then the similarity of the goods and services. So that's what an examiner is going to look at. And then essentially the rest of it is any other relevant factor. So as you're looking at whether I should use a trademark, you know, consider those two big categories and then any other relevant factor. Really, it's completely open-ended. So I don't want to leave the federal trademark registration process without asking if you guys have any questions or want to talk about any particular points there. So please interrupt me if you want to do that. So now, once we have the registration, so my suggestions are, you know, look before you leap, conduct a trademark search, determine if anyone's using it, you know, to the point about domain names. That's a great way to start, is if somebody has a registered domain name, you might want to look into that. And then, you know, if you remember nothing else from this presentation, just file as soon as possible. The wind is at your back if you have a federal trademark registration. So now as general counsel, you have your trademark registration. What do you do with it? So we have to maintain our marks between the 5th and 6th year, and every 10 years thereafter. Registration, we have to file a statement of use saying that we continue to use that mark. Again, you only get a mark if you're using it. And then I love this phrasing: variety is the spice of life, but consistency pays the bill. Like, consistently use your mark. Go back to the California Pizza Kitchen. What an incredibly weak mark, but you will never see, like these companies down here, you know, you'll never see their logo in any other shape, any other color. You know, reinforce to the consumer that this is our brand, this is who we are. And how do you do that? I don't know, does anyone have brand standards with respect to their company, been involved in that? Please, if you don't, like, this is so incredibly important, especially in the world of the internet. And it doesn't apply to all businesses, but let's say the company that I was general counsel of, we were selling motorized window shade through a network of dealers. Like, our dealers want to promote our brand. So we had to give them, you know, where is our logo? Where is our typeface? Where is everything? So, you know, your customers, the parties that you work with, they don't want to do it wrong. They want to do it right. So help guide them. And so this was, you know, the brand standard document that we had at the company I was general counsel of. I mean, it was incredibly thorough. It laid out everything. It provided, you know, the logo and the font. I mean, right down to these little colored boxes that you were supposed to use. And that way we were able to control this worldwide network of dealers and distributors and making sure that they were consistently using our trademark. And then to the point earlier, police your mark. How do you do that? You know, first thing is in-house. Like, look in-house. Train your people. How are we supposed to be referring to our products? What trademarks are we supposed to be using? And do periodic internal reviews. And then do the same thing out of house. So Google alerts for your unique trademarks. You know, take some time you know, as often as you can, but do Google searches. Put your ear to the ground and listen to what your customers and consumers are saying. If they, you know, that's often how all the people out there are essentially your little searching agents. So use them to help you, and then you know, pay attention if there's actual confusion. If you get if you're getting phone calls for somebody else, like, we know that there's an issue out there, and the issue might be even bigger because you're not getting the phone calls that you should be getting. And then equity certainly favors the vigilant. The sooner you take action, the easier it is to change the other side. So I have about 10 minutes here left. I do have, I think I sent to Christy this internal trademark clearance process. I have some forms in the back if anybody's interested. But the key takeaway here is, you know, please understand that the internet is changing the game when it comes to trademarks. Consumers don't even, it's gotten even past typing. They want to say one word or two words into their phone and get to the one entity in the world that they're trying to get. That's a tall burden. And the issues are rampant if we don't do it right. So I have a form that I'm happy to send you home with, but it's just how do I evaluate new trademarks? So, you know, first step is, you know, are you aware of anything in-house? Then just do a Google search and then go to the uspto.gov. And by going through that process and evaluating using the standard of whether there's a likelihood of consumer confusion based on the similarity of marks, the similarity of the goods, you can clear a lot of the low-hanging fruit. And then once you get past that, you know, low burden, then you can bring it to someone like me and I can give you my opinion. But I will tell you, you know, having been through this by the cases that I presented, front-loading this work is the best thing that you can do, and then doing it right just means the wind is at your back. So have a few more minutes here for questions. Happy to talk about anything. Any particular, please.
Run-of-the-mill trademark with no conflict. Is that what you spend by having done?
Sure. So my firm, we file a federal trademark registration for a flat fee of $9.95 for one international class of goods and services. So that includes the $275. Generally speaking, the process takes about a year, and you have about an equivalent amount of cost over that year. And what's that cost related to? You know, everything that, when I agree to file a mark on your behalf, I'm your representative of the Patent and Trademark Office. Everything I get from them, I have to report to you, and everything has a deadline associated with it that we have to respond to the Patent and Trademark Office. So it's really a lot of that going back and forth. So long as we don't hit a substantive issue, you know, it's about another $1,000, and it takes about a year. However, if we run into a substantive issue, it can get very, very expensive. For me at least, before you incur any of those costs, I'd give you a phone call and say, look, this happened. You know, we got rejected. Somebody filed a similar mark 2 days before us, which I can't tell you. It always seems 2 days is the thing. If I could just talk to clients 2 days earlier, but but also many times in those more expensive situations, we know this ahead of time. We've already seen some issues, and we're aware that we're, you know, trying to thread the needle, or there's some close calls there. And there's a lot of arguments that we can make on your behalf to register a mark. So did that answer your question? Good. Any other questions about the trademark process or what I do? Yeah, Jennifer. So really, for the benefits, to summarize that, the benefits of, you know, the costs are relatively low to protect your mark. The benefits are great versus, you know, when you're involved in litigation. I mean, that's tens to hundreds of thousands of dollars. Jennifer.
You touched on the state trademarks. I was wondering if you could expand a little bit on why would you use those instead of a federal, or do you tag team and do them both at the same time? If you could just expand on that.
Sure. So when you have a federally registered trademark, you get the presumptive right across the entire country. The state trademark essentially gives you that in the state. However, federal law trumps state law. So if you registered your mark at the state level and somebody had already registered the mark federally, your trademark is you know, really has no value. They used to be valuable. There are a lot of like state chartered businesses like banks where they can only operate within a state. But every bank now has a website, and their clients go to Florida and access their accounts during the winter from Florida. So it is really, again, I've filed probably well over 1,000 federal trademarks and 1 or 2 state trademarks. In those particular cases, there was always a reason why we did it. So I believe one was like a janitorial service company. They only wanted to operate in Iowa. Somebody had was using it in other places. And it was kind of a prophylactic measure to try to prevent somebody from stopping us, even though maybe we had some questionable common law rights, and maybe we had you know, some other issues that we were facing. So again, as I said earlier, I see a trademark as a sword and a shield. A sword meaning you can use it to stop others. A shield, like it was just one thing that we could throw up, but we registered our mark at the state level. I don't know if it really would have worked for its intended purposes, but it was something that we did. Now, okay, yeah. So get your answer there, please.
Nowadays, with a lot of social media, we do a lot of marketing, and part of that is the use of hashtags.
Sure.
Do you have any protections, especially if what protections can we as counsel do if our company is investing significant amount of money in certain hashtags that are not really specific as to the company, but a little bit more descriptive?
Sure. So, and I've actually looked into that, and it's an interesting trend, both, kind of in two categories. Is one, .com, like, so trademarks that are .coms, like you think of hotel.com. There's, I don't know, 20,000 trademark applications that include .com in them, which I think is very interesting because you already own the domain name, but like hotels.com, that really serves as a trademark. So a lot of entities are going the extra step. I mean, their trademark is not hotels. It's hotels.com. And then hashtags. I've filed a number of marks that include hashtags. And the interesting thing there is we want to be, the interesting thing about hashtag trademarks is, you want to encourage others to use that hashtag, yet you're protecting the mark to prevent others from using there's a little bit of a conflict there. But let me just think of an example. So Research Foundation wanted to promote this, concept, so hashtag whatever. They wanted that to be viral, but they wanted to be the only ones that were collected the donations and were the party that sponsored that. Like I think about ALS, something like that, where they were promoting it that way. So it's kind of, they're very unique, something to think about. And so do you work for a marketing firm or?
No, I work for a company that owns several of those.
Okay, sure.
So yeah, that's hashtag.
Sure. And do the hashtags include the trademark themselves, or is it totally unrelated? Sure. Well, it would be something to consider because you don't want to, what owning that trademark would do would prevent others from kind of promoting that hashtag for their own benefit. But it's kind of a peculiar way of using trademarks, but certainly been done before many times. So.
We also have a question via the web.
Sure.
So if a name of the business is the last name of the founder with no additional characters, would that still be considered a fanciful trademark?
So again, going back to the sliding scale of trademark strength, I said that you can't get a trademark if it's simply generic, meaning it's just descriptive. And what is your name? It's descriptive of you. So the Patent and Trademark Office kind of hits the pause button on registering names as trademarks. Now, if you can prove that you've been using it for a while and you've developed some trademark rights in it, then they are willing to grant you a trademark. But it just, again, it's a little bit of a wrinkle. It's certainly, think about the great trademarks like the Sukup here in Iowa. You see it on their grain bins all the time. That's the last name, and it serves as a great trademark. But you have to, establish rights, use it in commerce, and it's just a little bit of a wrinkle that we have to handle, and certainly can be done. And the other, well, I'll leave that. So looks like I only have about a minute or two here. If anybody wants trademark selection form or evaluation form, I have them back there. My summary here is trademarks are very easy to register. The wind is at your back. Look before you leap. And then when you have trademarks, certainly pay attention, police your marks, and the earlier you pursue against other parties, the better off you are. And certainly trademarks are very simple things, really in many ways, but the complexity kind of gets off the charts. Reach out to counsel that deals with this all day, every day, and that'll help you in your endeavors as well. So with that, I really appreciate your time, and hopefully I serve my purpose here. So thanks.